Case 3143, Child versus Hudson. All parties please come forward.
Taylor Child is suing her former friend, Crystal Huddleston, for the cost of a motorcycle and riding boots.
I know very little about motorcycles. I know that the couple of times I've been on them, I didn't like it. Just seems to me that when you're surrounded with 3,000-pound cars, you want more around you than fresh air. So maybe I'll get somewhat of an education doing.
Crystal is countersuing Taylor for medical bills.
This child, you like motorcycles.
Correct.
And you've been riding them a long time.
Yes.
And you purchased a motorcycle from someone used, and you paid $3,500 for it.
Yes.
Who's Scott?
Right here, ma'am.
That would be him. You and Scott work on the motorcycles together.
Yes.
And you brought the motorcycle back to your place, and you did some work on the chain and a lube job and who knows what else. But then when you tested it out, Scott thought, according to you, it needed a little more work, and he was going to take it back to his house to do a little more work on it. So far, correct?
Correct.
So Scott took this motorcycle back to his house. Now, this young lady doesn't ride motorcycles, but she rides as a passenger on motorcycles. But she wanted to learn about it, and she, too, was a friend of Scott's.
Correct.
So she was at Scott's house while he was futzing around with this motorcycle, and she decided she wanted to ride it and wanted Scott to help her learn to ride a motorcycle. Is not an answer. Is that correct?
No.
Tell me where I'm wrong.
The morning of September 29th, Taylor had my riding equipment in her car, and she and I had an agreement that I was going to learn with Scott on the bike. The night previous, we had a group chat.
And at some point, you had to have asked her if you could ride the bike. You know, certain things are common sense, certain things aren't common sense. Don't think about your ultimate counterclaim here, because that's not going to be good for you anyway, in all probability. You understand that?
Yes.
First, we have to take responsibility for our own actions. But at some point, you asked her if you could ride her bike.
Yes.
Okay. And at that point, you knew the bike was at Scott's house.
Yes.
And when Scott gave you the bike to ride, you rode it alone.
Yes.
Had you ever ridden a bike alone before?
Yeah. Ryan's bike.
And Ryan is your
boyfriend.
Okay. When Ryan let you ride his bike 5 times, were you good at it?
I would like to think so.
Well, then what did you want to ride her used bike for? And learn how to ride?
I wanted to get more practice before I bought my own bike.
Okay, so you wanted to get more practice. Why didn't you ask your boyfriend if you could ride his bike?
Ryan and I were in a fight that morning.
So you mean instantly you had a fight with him in the morning, and then you were going to pursue your dream of motorcycle riding that day? Am I understanding you?
Yes.
Yeah. Okay, good. So this is what happened. So you got on the bike and you wrecked it.
Yes.
And she's suing for the wrecked bike.
Correct.
And you're counterclaiming because you said, I didn't know that it didn't have a lube job, and I was terribly injured, which you were, hospitalized, right?
Yes.
Because that's what happens when you ride something with just the air around you. You weren't in an accident with another bike or a car. You wrapped the bike around a tree.
Yes.
And of course, that had to be somebody else's fault. Not the fault of the rider who was learning how to ride, but it had to be somebody else's fault who let you use the bike to learn how to ride.
No, I take full responsibility for crashing this bike.
You take full responsibility. So why don't you pay her for the bike instead of countersuing her for $10,000?
The bike was unregistered, uninsured, and Taylor and I have an agreement, or had an agreement, that I would pay her in full by March 29th.
Pay her in full for what?
For the bike.
And
the boots that she gave me.
So you had an agreement with her after this incident. By the way, what was the date of the incident?
September 29th.
Okay, so you had an agreement after you destroyed the bike and after you recovered from your injuries, you had an agreement with her that you were going to pay her for the bike by March 29th.
Yes.
Why didn't you pay her?
I have been paying the medical bills off
Okay, well, that's fair. So, in anticipation of your not paying her back, she's suing you now, and you decided to counterclaim.
Yes.
That makes my life so much easier. Good. Did she agree to pay you back for the bike?
Yes.
She's telling you this in legalese, we call this an anticipatory breach. She's telling you now on March 19th that she's not going to pay you on March 29th. So 10 days from now, she's not going to pay you because she's been paying off the medical bills. That's why we're here.
Correct.
Judgment for the plaintiff in the amount of $3,500. Your counterclaim's dismissed. We're done here. Thank you very much.
This court is adjourned.
What happened is Taylor blatantly lied and said that I could ride her bike, and that's it. It's cut and clean. I crashed. I take responsibility for it, and that's it.
I didn't get full permission. It was discussed prior to the case, prior to the incident, that I would teach her, and they already had access to my bike.
I was on gravel. I lost control of the bike. I popped a wheelie, and then I popped another wheelie.
I received a call from Scott, my witness.
The clutch gave out, and I couldn't stop the bike, so I made a decision to not go into my car and go into a tree.
He said, "Hey, get here quick. Crystal's in an ambulance." She wrapped her bike around a tree.
Taylor and I are not friends.
We're not friends.
I don't like snakes. I'm sorry.